The man who leads the NDC's communication is Sammy Gyamfi. He's joined us on the line. Mr. Gyamfi, you're welcome to Eyewitness News. The Electoral Commission has issued a statement saying everything you have said flies in the face of what the Constitution dictates, and that whatever is happening is a constitutional process that is going to be abided by. So your claim is unfounded. The issue of transfer of a candidate from one constituency to another.
Well, that position by the Electoral Commission is not borne out by the facts and the totality of the electoral laws of this country. In fact, it is a very uninformed, unreasonable, and absurd argument the Electoral Commission is putting forth on this matter. Not all the laws of this country are written in black and white in the 1992 Constitution. The 1992 Constitution gives powers to various institutions to make subsidiary legislation. If all our electoral laws were written and captured in the 1992 Constitution, there would not be any need for constitutional instruments, what we call CI. So yes, it is true that per Article 94 of the 1992 Constitution, one only has to be a Ghanaian of 21 years and above and of a sound mind, and should hail from an area to qualify the person to be elected as a member of parliament. We know that that is the eligibility criteria set out under Article 94 of the 1992 Constitution. But Article 51 of the 1992 Constitution has given the EC the powers to make regulations by constitutional instruments to regulate the conduct of public elections. And currently, the constitutional instrument that governs public elections is CI 127, passed in 2020, which is the EC's own law. Now, Regulation 6 of that law provides for nominations. And we are saying that you can satisfy all the constitutional requirements set out under Article 94. But if you fail to satisfy the requirements of CI 127, you can be disqualified. Now, in the instance case, the third NPP parliamentary aspirant, Charles Opoku, does not satisfy the requirements of Regulation 6.3 of CI 127 when it is read together with the requirements of the EC's own nomination form for the Aston North by-elections slated for the 27th of June 2023. If you take the nomination forms for the by-election, which was published on the EC's website on 1st June 2023, it is explicit that a candidate in the Senate by-election must be proposed, seconded, and endorsed by 18 registered voters. In total, 20, because you need a proposer, a seconder, and 18 endorsers, who must be registered voters in Aston North constituency per Regulation 6.3 of CI 127. And the EC's nomination form says that these proposers, these seconders, these endorsers must be of the same constituency as the person they are nominating to be elected as MP. So if the said Charles Opoku is not of that same of constituency because he doesn't vote there, he votes in Takwam Swahili, then the attempt by the NPP and the EC to surreptitiously insert or smuggle his name into the Aston of voters register is totally unacceptable, given the fact that the time frame allowed for voter transfer has elapsed. And so we are only sticking to what the EC themselves have written in black and white at the second paragraph of part 1 of the nomination forms for the Aston of by-election, which says that the people nominating you, proposing, seconding, and endorsing you as a candidate must be of the same constituency as you. You are of Takwam Swahili, you are not of Aston North. That is what we are talking about. If the NPP has any issue with this, they should trash it out with the Electoral Commission because the NDC didn't make those rules. We didn't publish the nomination form, and we didn't pass CI 127, which is what we've used to govern the conduct of public elections in this country since 2020. In any case, how come that Dr. Papa Kwesi Indium, Odike, and those people were disqualified by the EC in the run-up to the 2020 election? Were they disqualified based on the eligibility criteria set out in the Constitution? No, because certainly all of them are Ghanaian citizens, 40 years and above, and of a sound mind, and therefore they meet the fundamental eligibility criteria provided for in the Constitution. However, they were disqualified because they failed to comply with the nomination requirements set out in the EC's subsidiary CI. And that is why their nominations were rejected. But for the fact that the EC failed to give them a hearing and an opportunity to rectify those anomalies, their disqualification would have been upheld by the court. You see, so that argument by the Electoral Commission, which is being rehashed by their collaborators, the NPP, is totally flawed. It's not just, when it comes to eligibility requirements, it's not just about the Constitution, but it is what our electoral laws in their totality provides for. And CI 127 has specific requirements on nomination, which all candidates in this upcoming Assembly election must comply with. Now, we've not got into that stage yet, but we are saying that the NPP, knowing that that aspirant of theirs doesn't vote in Assembly, are engaging the NPP behind the scenes to illegally smuggle his name into that Assembly register. And that is what we have served notice that we will not accept that, we will resist that.
Sammy, so you're saying is in effect that a CI is disqualifies someone who is qualified by the Constitution. Is that workable?
No, not at all, because it is the Constitution. The CI gets its validity, its legality from the Constitution. Not every law can be written in the Constitution, the parent law, the supreme law. So the Constitution at Article 51 has given the EC powers to make laws to govern public elections. And unless those subsidiary laws are inconsistent, are found to be inconsistent with the 1992 Constitution, they are supposed to be obeyed. If they are found to be inconsistent, they will have to take the Supreme Court to make such a declaration under Article 1, 2, and Article 2 of the 1992 Constitution. But as I speak to you, the Supreme Court has not annulled or declared as unconstitutional CI 127 and its provisions on nomination.
Okay.
And so the laws on eligibility in the Constitution, the requirements on eligibility in the Constitution, Article 94, should be read together with requirements for nomination in the Public Election Regulations 2020 CI 127. And if you read that, you will realize that per the EC's own provisions, that gentleman is not qualified. If they think he is still qualified nonetheless, no problem. Let his name remain at Takwan Swayim, and let the good people of Asin North know that one of the people the NPP is seeking to present in this by-election has not even deemed them worthy to register and vote with them, but rather vote somewhere. But to surreptitiously smuggle his name into the register when the time frame for voter transfer has elapsed is totally illegal, and we will not accept that. That is what you say.
All right, so I mean, this person may or may not win the internal primaries of the NPP, which means there's a possibility he may not even be on the ballot. But do you have concrete evidence backing this claim of yours that his details are in the Takwan Swayim register and not the Asin North constituency register?
My brother, I have conclusive evidence on that matter.
You want to share details?
Oh, I can forward that to you immediately, because we have checked the entire Asin North voters register. His name is not there. His name is on page 28 of the Takwa Swayim voters register. Page 28. He's there, Takwa Swayim. His name is Charles Upuku. And you can check your WhatsApp now. I have forwarded it to your WhatsApp. You can check that for yourself.
But Charles Opoku could be anybody from Takwan
Oh, his
Swahili.
picture is there. His picture is there, and they can't dispute that. You understand? They can't dispute that his picture is there.
God, the Electoral Commission has said.
Just read. Or if you want me to read it, I can read Regulation 6, Sub Regulation 3 of CI 127 for you, because CI 127 says that the people who will be proposing, seconding, and endorsing your nomination must be from the constituency you are contesting in. For the avoidance of doubt, I read: a candidate for election to Parliament shall be nominated on a nomination form in a manner determined by the Commission. 3 reads: the nomination form for each candidate in an election to Parliament shall be witnessed by the signature or mark of 2 registered voters as proposer and seconder, and supported by 18 other registered voters in the constituency as assenting to the nomination. In the constituency, the definite article. So you can't go and bring registered voters in Bolegatanga to come and endorse your form for you to contest as MP in Asen North. They must come from Asen North. And the Electoral Commission, in their own nomination form, Sandra, I'm forwarding that to you as well. We didn't publish it. They have published the nomination form on their website, 1st June 2023, Part 1. This is what it reads: we, the undersigned registered voters in Dododo constituency, do hereby nominate Dododo of the same constituency to stand for election as a member of parliament. Of the same constituency. You don't vote there. How are you of the same constituency? Was it Sammy Gyamfi who wrote this thing there? So if the NPP have an issue with it, they should trust it out with the Electoral Commission.
But the Electoral Commission has said there's no application for a transfer of votes in this particular gentleman's name yet.
You come today and see the people who have been incarcerated. Many of them went to court. Some of them were armed robber suspects. Most of them pleaded not guilty, yet they were found guilty. The fact that somebody gives you a mere denial to an allegation doesn't mean that they are speaking the truth. You look at the consistency between the EC statement and the NPP statement. Don't you see that they are collaborating together?
Let's move forward.
Why can't they be explicit?
Let's move forward.
They admit that the guy doesn't vote there. If the guy doesn't vote there, the people of Asen North deserve to know that this.
But if you don't vote there, the Constitution has said even if you don't vote there and you hail from that constituency, you are.
Where is that written?
It's in the
Constitution. The Constitution says you must be a Ghanaian, 21 years and above, and a registered voter. Why must you be a registered voter? Because you cannot be voted for in an election that you cannot vote in. So this guy we are talking about.
So Sammy, you
can't hold on. He can't vote in the election.
But he can vote. But he can vote in Takwan Swahili. He's a registered voter. It does not say registered.
He should go and contest there.
No, but I'm saying that the law does not say you should be a registered voter in the constitution. It says registered voter.
That is the Constitution, and yes. I've told you that not all the.
No, just a second. Let's get it. So in the Constitution, it says you must be a registered voter. And then the Constitution also says you should hail from the constituency or should have lived in the constituency for at least 5 out of the last 10 years before the election. So if he satisfies that criteria, he goes through. Is that no problem? Anyway, let's move on. The Supreme Court.
No, Sandra, hold on. Just something small on that. And that same Constitution you just quoted has provided for under Article 51 that constitutional instruments should be made to govern public elections. And the constitutional instrument is saying that the people who nominate, propose, second, and endorse your form must be from the constituency you are standing. And the EC is saying that you should be of the same constituency with them. So is it the NDC's creation or is it the EC's creation?
Very well.
And is it a crime to stand by what the EC has provided for in the nomination form?
Moving forward, the Supreme Court has released a full judgment on Asin North. You're a lawyer. You've read it. Any comment on it before we go?
Well, this 35-page judgment from the Supreme Court has confirmed our position that the decision the Supreme Court has taken to annul the election of Honorable James Dashi in MP for Asin North is nothing but a travesty of justice. You read the entire judgment and you get sad as a Ghanaian that clear provisions of law in this country were completely disregarded by the Supreme Court in arriving at the conclusion they arrived at. Number one, Section 20D of the Representation of the People's Law, NDC Law 284, is clear that a parliamentary election can only be cancelled if that parliamentary candidate was not qualified at the time of his election. Emphasis on at the time of his election. That is Section 20D of PNDC Law 284. The Supreme Court says that that same North parliamentary election was held on 7 December 2020. And at the time of that election, the Atiku had received a certificate of renunciation of his Canadian citizenship. He received it on 26 November 2020, according to the Supreme Court, 10 clear days before his election. But the Supreme Court said that no. Even though he was qualified before the election, that is not enough. He should have been qualified before his nomination. And that he submitted his nomination form to the EC on 9th October. And that since the certificate of renunciation came in on 26 November 2020, he was not qualified by 9th October 2020 when he submitted his form. But the law says he should be qualified as at the time of the election. In any case, when the Supreme Court says that he should have been qualified as at the time of the nomination, let's assume for purposes of argument that they are right. It is not at the time of election, as is explicitly written at Section 20D of PNDC Law 284. What is nomination period? In the Papa Kwesi Indian case, the Supreme Court stated that the nomination period is not just the period where a candidate submits his form to the EC. Because when you submit your form, the EC must vet that nomination form. They must scrutinize it to either accept or reject your nomination form. And that the period they use to investigate that nomination period, that nomination form, is part of the nomination period. And that is why in the Indian case, the Supreme Court said Indian should have been given a hearing by the EC even after he submitted his form. And after he submitted his form, he should have been given an opportunity to correct the mistakes he made because the nomination period had not ended. It is not the submission that terminates it. Now, in the case of Honorable Jachi Kwesi, he submitted his form on 9th October. But the EC, after the submission, began to scrutinize his form. It was during that period that a group of NPP activists calling themselves Concerned Citizens of Asenos petitioned the EC to reject the nomination of Jachi Kwesi. And so Jachi Kwesi was invited to the EC's headquarters in Accra on 27th November as part of that of investigations into the validity of his nomination. And after 27th November, when he appeared before the EC in Accra to answer or respond to that petition, he had received his certificate of renunciation a day prior, that is on 26th November 2020. This is why the EC, who didn't have a gun to their head, in their own wisdom, cleared him because they saw evidence of renunciation of his Canadian citizen.
Well.
Now, after he has gone on to win his election by an unprecedented margin, you now go to court and say, even though he satisfied all the nomination requirements before nomination closed, and you cleared him to contest, at the time he submitted his form to you on 9th October, his certificate had not come, so he's not qualified. What kind of cock and bull story is this?
Let's leave it here. Thank you, Sammy Gyamfi.